Good afternoon, everybody.
Afternoon, Judge.
Do y'all want this taken down?
Plaintiffs do not believe they need it, Your Honor.
Yeah, I don't think we'll need it either, given our conversations earlier today.
Great. All right. Well, Ms. Barber, thank you for being here.
You're welcome, Judge. Y'all have a good afternoon.
All right, you too.
Thank you.
Thank you.
Okay, well, that sounds promising. So I'll let y'all tell me what y'all discussed and came and figured out.
I'm happy to do it, or Colleen, if you would like to, that's fine too.
I'll let you do it since it's your motion.
Okay. All right. So, Your Honor, good news to report. I think we've mostly figured this out.
Okay.
You know, we sent the request to an expert, to a non-party request, and they objected on procedural grounds. And we have discussed the matter, and we're going to use a different form of request. We're going to subpoena, and we've consented to doctors' depositions on both sides because the plaintiff required additional treatment, and so we've said it's okay if they need to depose our expert, and likewise they would allow us to depose their expert. So I think for the most part we don't have any dispute at this time.
Okay.
Colleen, is there anything you want to add or go over?
Just, you know, we had filed a motion to amend pretrial order, hasn't been ruled on. It kind of is at the same issue involving Dr. Lundy. You know, if just to jog your memory, Judge, this case was set for trial. The plaintiff wanted to get some additional treatment. I believe he's still in the process of getting that treatment, to my knowledge.
Correct.
But the parties entered a pretrial order way back in the fall. And I think both Catherine and myself think that we might need to do both sides an amended pretrial order to kind of account for some new medical treatment and experts.
Okay. So is there going to be a point at which this case is ready for trial? That's what is that going to be in this amended pretrial order? Because we've reset this now a number of times off trial calendars. Is there going to be a point?
Yeah, yes, Your Honor. So it was a knee surgery, and the knee surgery, right, the knee surgery will be done, and we'll just be looking at physical therapy after that. So I have every reason to believe that after the surgery is completed, that we'll be able to proceed with trial.
I guess what I'm asking is, do we know, is it scheduled? Because I thought it had already been scheduled, but
it was, Your Honor. It has been rescheduled for the 16th of this month, and the reason is because the plaintiff had a change in his health insurance, and the doctor that he had it scheduled with did not accept his insurance, so he had to find a different doctor who was in network. So it was starting from scratch again. So it's been a little difficult, but Colleen and I have discussed it, and it seems like for the most part I don't see any genuine dispute at this point.
And when y'all talk about deposing each other's experts, is that we're talking about Shawnee Katz? Is that who we're talking about? Because there was an objection, I know, way back when, to a medical narrative. Has that been resolved, or will that be resolved?
Sorry, I didn't mean to interrupt you.
No, you're not. I'm asking.
So I think that, you know, at this point, our objection stands to the extent that the medical narrative plan to introduce that at trial. You know, some of the sections of the objection, one was a timeliness objection. Obviously, there's no longer the timeliness issue with regards to the ability to take her deposition as well. We had talked about that. I know there was it's not certain whether you're going to introduce the medical narrative, but I think plaintiff is leaning towards introducing that. To that extent, I think we stand by our objection to the speculative nature of the medical narrative and some of the undefined terms.
So have you already taken her deposition?
We have not.
Okay, so on that ground, there, you're saying there's no objection on that. You're talking about on things other.
Yeah, there were a couple
people of those.
facets
Okay,
to our objection, and I think to the substance of the medical narrative, our objection stands, but to any of the procedural issues that we had with it, obviously, we think those are moved.
And just from my viewpoint, I wasn't here when the objection came in, and I just reviewed it in preparation for today, Your Honor. And in terms of where I stand, I am inclined to want to use that as evidence at the trial, and any sort of untimeliness that is moot at this point, right?
Mhm.
But I would also say, since I anticipate taking their expert's deposition, I would say they likewise can depose Dr. Katz, who wrote the medical narrative, just to clear up any sort of uncertainty that their objection stands on. I have no problem with them deposing the doctor.
right. Well, we talked about conferring after the deposition if that was going to be scheduled previously, but if there is, let's do this. Why don't y'all talk again? Now you're continuing to talk, and if y'all are actually starting to work together, that is a nice change to this litigation thus far. And why don't y'all try to work together on those issues? What I heard Ms. Callahan saying is undefined terms and speculative nature of the narrative. Now, not sure that's a grounds upon which to object to a medical narrative, but under the statute, but that's something I know that comes up from time to time as an objection. Y'all can talk about that. And if you need to clear up any undefined terms, you may want to decide if you're going to do that or if you want me to actually rule on that objection prior to trial. So at least you'll know what those are and see if those need to be cleared up. Okay.
Sounds good.
Sure.
Thank you.
All right. Well, then we will look forward to an amended scheduling order on this one. Then you're telling me that we're going to be able to schedule trial based upon this scheduling order, right?
Yes,
I
sir.
mean, yes, the only thing that I would say is it sounds like there's another new treating provider that I wasn't aware of. So we'll need to get those records, and they're out of state records, but yes.
Is there, okay, so let me come back to this a little bit on working together. Obviously, to get a retained expert's information who's out of state, you can go the subpoena route or deposition, or obviously y'all can work together and provide those records voluntarily. But it looks like it has been, from my perspective, neither side has been very, from my perspective, because I've dealt with this a number of times, has been very willing to actually work together. And it seems it's because, well, they did this, so I'm going to do this. You did that, so I'm not going to be helpful here because you weren't helpful there. And maybe what we can do going forward is, at this point, leave behind some of that issue and just agree to work together. And say, for instance, getting medical records, that should be something easy for the doctor to get his own medical records. And I don't know how doctors are with other doctors, but sometimes I would imagine that might be helpful to be a doctor or request your medical records and get those sooner rather than having to go through the out-of-state subpoena process. But hopefully y'all can work together.
Thank
Will
you,
y'all be
Your
able
Honor.
to do that? I'm just going to ask you, will you be able to do that?
I
Yes,
believe
Your
so.
Honor.
Okay. All right. Well, great. Well, that sounds good. Bill, anything else that I have forgotten to cover?
No, just for clarification, though, plaintiff will be withdrawing their motion to strike the expert witness.
Yes.
Okay, thank you.
Okay. And then that, your motion to amend the pretrial order, it was filed a few months ago or a couple of months ago. You're going to update that and okay, got it. That's fine. So the only thing that we'll need to potentially rule on, but you're going to look at, is the objections to the medical narrative. However, the procedural issues are moot at this point, and y'all are going to talk about the remainder to see if that's something that the court's going to end up having to rule on.
Yes, Your Honor.
Yes, Your Honor.
And I think we got it covered.
Thanks
Thanks,
so
y'all.
much.
Y'all
Thank
take
you.
care.